Hey guys, hopefully my fan isn't on too loud. I got it on in the background. You have to let me know if it is. But I realized I've only done one live stream in the last 2 weeks. So I went from being very active to kind of like disappearing. And if you don't follow the Laura Owens thing at all, you probably didn't hear me explain. I've had like a hurricane of reasons where I just kind of disappeared for a little bit. So I picked up a second job again recently just to get some extra money for, paying bills and hopefully traveling later in the summer. And also, I got a little bit sick for a minute. And then I was supposed to take the LSAT this month, which was stressful. And so I started cramming and freaking out a little bit. And I was like, why am I rushing this? So I once again put it off so that I can chill when I'm taking it. Things got really busy towards the end of last month. You guys know I went out to New York. Like I said, I just started a second job again. So before I get into the swing of things, it was kind of like I have so much going on. So I put that off again. I'll probably be doing it. I'm thinking after this trial, if it happens, the Baldoni trial. So sometime in the summer. I don't need to rush it. I don't know why I keep trying to rush it. So I'm going to do that. Anyways, this lawsuit, you guys might have even forgotten about it because I forgot to check. And sorry, I just realized my hair is serving middle school boy tonight. But you guys might have forgotten about this. So I forgot to check this docket where Brian Freedman, the lead attorney for Justin Baldoni, was being sued because of statements he's made while representing Baldoni against Blake Lively. Now, the person suing him is Clement Suri, who is the surviving spouse of Travis Flores. And as you guys know, most of you guys know, Justin Baldoni was involved in a lawsuit with Travis Flores a while back. It's almost 5 years ago now, I think. And, I won't go through the whole lawsuit against Brian tonight. I put a link to the stream where I did go over the actual lawsuit in the description of this video if you're interested in seeing that. I'm just going to go over Brian's kind of response to that. He has filed an anti-SLAPP hoping to dismiss this thing. And he, gave an answer to the complaint, which is not, the answer document is like not that much of a page turner. So we're not really going to go through that tonight, but I will show it to you. But hold on, I'm trying to pull up some documents here. The gist of the lawsuit by Travis Flores' estate. So it's the surviving spouse, Clement Suri, and then also on behalf of the estate of Travis Flores. They're suing Brian and his firm, and they're saying that he took money to represent Travis in a copyright lawsuit against Justin Baldoni and related, companies who worked on the film for 5 Feet Apart over Travis's screenplay for 3 Feet Distance, saying that Baldoni's movie 5 Feet Apart was kind of ripping off of 3 Feet Distance. The lawsuit that the estate filed says that after filing the copyright suit, Freedman quickly told Flores to abandon the lawsuit and pushed him to sign a settlement that paid him nothing and that Brian performed minimal legal work. So it alleges that once Brian started representing Baldoni in the litigation against Blake Lively, he made public media statements that praised Baldoni and said the copyright defendants did nothing wrong, the copyright defendants being Baldoni, Wayfair, etc. Statements that Flores' estate claims undermined Flores and disclosed confidential or privileged information. So they were suing him for breach of contract, legal malpractice, invasion of privacy, defamation, among other things. So, but let's get into the actual documents we're going to go over tonight. Hang on. Give me 1 second here, guys. Okay. So this is the actual answer, which was filed a couple months ago, or not a couple months ago. God, it's been a while, dude. It's been a while since the lawsuit was filed, I guess. But we just kind of forgot about this, I feel like, which is, not all that surprising, given everything that's been going on in the actual main Baldoni Lively case, and then there's the Jones case. But this was the answer to that, which has, not too much interesting substance if you're just like a layperson, so I'm not going to read all this tonight. They do a general denial and they have all of their affirmative defenses. And then I'll just read you the bottom here where it says what they're asking for. It says, wherefore having... Hang on. Okay, I had to make sure I wasn't muted still. It says, wherefore, having fully answered the complaint, answering defendants respectfully hereby request that the court enter judgment as follows. That plaintiff takes nothing by reason of his complaint, dismissing the complaint in its entirety with prejudice, awarding costs and attorney's fees in favor of defendants, and granting such other further and different relief as to this court deems just, equitable, and proper under the circumstances. So we'll get into the actual like anti-SLAPP motion, which is where all the interesting stuff is, interesting arguments. But I wanted to show you that real quick, but we're not going to read over that whole thing because it's not really going to tell us much more than this will. One sec. 5 Feet Apart was a good movie. I didn't know Justin Baldoni produced that movie. Yeah. I actually haven't seen it still, surprisingly. I've seen It Ends With Us. I have not seen 5 Feet Apart. I need to fix that. So, one sec. I feel like I need my hat. Okay. So, he's asking for this stuff to get thrown out on anti-SLAPP, which if you don't know what anti-SLAPP is, it's like you can't punish someone basically for their free speech or their legally protected speech. And we'll get into that here. So, hold on. This was a 400-something page document from LA Superior Court, which is not fun because LA Superior Court is actually way more expensive than Pacer a lot of the time. And they wouldn't let me like pick and choose the pages that I wanted to buy. Of course, you have to buy the whole document. So I did cut it though, so that we didn't have so much exhibit stuff to sift through that we've already seen, which is like stuff in the Flores lawsuit, stuff in the Lively lawsuit. It was just attached like docket pages and lawsuit pages that we've already seen. So as far as the Flores lawsuit goes, there's going to be a lot that goes into this document that has to do with that. There's a little bit of a letter, a legal letter that I think explains what happened in that lawsuit that we'll read a little bit of. I went through and highlighted some portions, but I'm not going to go over the actual Flores lawsuit and all that attached to this tonight. We're just going to go through this document. So give me one sec. Oh, and by the way, guys, at midnight Eastern, so in 2 hours, I'm going to be on Omar's channel. So I'll redirect you guys to that link after this one. This stream isn't going to be that long, but that is scheduled for midnight Eastern, 9 p.m. Pacific. And it's going to get real political over there, so it's going to be a much different stream. That's just if you want to watch. I'll put the link when we're done here. It'll redirect you there, and you can find it. But right now, we're just going to go over this stuff. I'm not going to do any politics here. So, all right. Let's see. So it says this motion, and this is filed by Brian Freedman, right? This motion is made on the grounds that the complaint and each of its causes of action, in whole or in part, is subject to the anti-SLAPP statute because it arises from the exercise of defendants' rights of free speech and petition and conduct in furtherance of those rights in connection with issues under consideration by a judicial and or other official body and issues of public interest. That is a mouthful, but we'll get into the easier explanation of that shortly. In particular, the complaint in each of its causes of action arise from defendant's speech and conduct in the context of litigation, including without limitation speech and alleged speech to the public and the media about judicial proceedings and or matters and persons of public concern, including matters and issues about which the press and public have demonstrated consistent interest. So the speech that they're, complaining about is related to the Lively and Baldoni litigation, so it's a matter of public interest. Okay. Therefore, the complaint in each cause of action, in whole or in part, falls within the scope of the anti-SLAPP statute. Okay. Plaintiff's 5 causes of action, or alternatively portions thereof, should be stricken for the following separate and independent reasons. Let's see. Okay. The complaint in each of its causes of actions are barred in whole or in part because the allegedly actionable statements made to the public and media and conduct in furtherance thereof are privileged under Civil Code Section 47D, or the First and 14th Amendments to the United States Constitution and Article 1, Section 2 of the California Constitution. Okay. The complaint's 5th cause of action for defamation is independently barred for additional reasons. A deceased person cannot be defamed. The estate of a deceased person cannot initiate a cause of action for defamation. The allegedly defamatory statements were not of and concerning Flores, who is deceased, or Suri, who brings the defamation claim. And remember, Suri is the surviving spouse, and alleges harm in his individual capacity as administrator of the estate of Flores, and did not state or reasonably imply anything defamatory about either of them. Okay. And the allegedly defamatory statements were non-actionable statements of opinion. Okay. The complaint's fourth cause of action for invasion of privacy is independently barred because plaintiff cannot invoke or initiate a claim as to a decedent's common law right of privacy. The allegedly actionable statements were not about Flores or Suri. Okay, and Suri is alleging these harms in his individual capacity as the surviving spouse and on behalf of the estate. Okay. The allegedly actionable statements were not offensive to a reasonable person. To the extent the privacy claim is for the alleged publication of private facts, it fails because the allegedly actionable statements were not private. They were newsworthy and not highly offensive to a reasonable person. Okay. And to the extent the privacy claim is for false light, it fails as superfluous. The complaint's first cause of action for breach of contract, second cause of action for breach of fiduciary duty, fourth cause for invasion of privacy, and fifth for defamation are barred in whole or in part because the allegedly actionable statements made to the public and media are privileged under Civil Code Section 47B. The complaint's causes of action for breach of contract, breach of fiduciary duty, and legal malpractice should be stricken because they're not trying just to get this stuff thrown out. They're trying to get it stricken from the record. Should be stricken at least in part because defendants did not represent Flores and Flores' former legal adversary Justin Baldoni at the same time. Defendant's subsequent representation of Baldoni was not in the same or similar matter as prior representation of Flores. So Flores' suit was a copyright suit, right? And the Baldoni Lively action is clearly quite different. It's about sexual harassment and alleged retaliation. So defendants did not disclose any confidential and or attorney-client privilege matter. Such claims are superfluous of and fail for the same reasons as the defamation claim. Okay. This motion is based on this notice, the attached memorandum, the declarations of Brian Freedman and his attorney Jeff Payne. Defendants respectfully request that this court strike and dismiss in whole or alternatively in part plaintiff's complaint and each of its causes of action in whole or in part with prejudice and without leave to amend. Defendants also request the court enter an award of attorney's fees and costs in their favor against plaintiffs. So there was supposed to be, and this was signed off on a little over a month ago, this motion. There was supposed to be a hearing on this anti-SLAPP next month, but I think it might have gotten moved. So I'm not positive. I'm going to have to check on that because it was initially scheduled for a different date. And then they asked to move it. So I'm not really positive if it's still going ahead in early March or if that's going to be a different time, but we'll find out and I'll let you know what I do. So, all right, let's go over that. Okay, 1 second. Okay. Brian Freedman and his law firm represented Travis Flores from July 2021 to March 2022 in a copyright and idea submission lawsuit against actor and filmmaker Justin Baldoni and others. Flores' complaint alleged that after Flores conveyed his script titled 3 Feet Distant to someone he learned was connected with Baldoni, Baldoni's film 5 Feet Apart took elements from Flores' script with resulting similarities between the two works. So this guy, Caleb Remington, they say that Flores conveyed the 3 Feet Distance script to Caleb Remington and that Caleb was connected to Justin Baldoni. And they say as a result of that connection, Baldoni's film 5 Feet Apart took ideas and elements from Flores' script via, taking them from Remington. So, all right. After Flores' complaint was filed, in September 2021, the defendants in that case produced extensive evidence of the independent creation of 5 Feet Apart, none of which was available to Flores or Freedman before filing the suit. Faced with this new evidence and a pending motion to dismiss, Flores agreed to a non-confidential walk-away settlement in March 2022, under which all parties denied liability. So it was like there was no wrongdoing on anybody's part. Freedman never met or spoke with Baldoni during the time he represented Flores. Freedman first met Baldoni more than 2 years later in December 2024, when Freedman began representing Baldoni in litigation against actress Blake Lively and others in connection with an entirely separate film, It Ends With Us, that had nothing to do with Flores or his prior dispute with Baldoni. Flores died in May 2024, more than 6 months before Freedman met Baldoni and started representing him, and more than 2 years after Freedman's representation of Flores ended. And I remember reading Clement's lawsuit on behalf of, Travis's estate and individually. And I remember thinking, like, I don't want to bag on this guy for filing this lawsuit because it must suck to be the surviving spouse of Travis Flores and to know the lawsuit, didn't go their way. And I don't think there was necessarily any wrongdoing on anyone's part, which is why they did a walkaway settlement, which was non-confidential. But it would suck to be the surviving spouse of Travis Flores and then to see that it's the attorney, Brian Freedman, I guess kind of representing the other side, even if it is in a different case. And I guess I could see why the surviving spouse would be emotional. I could see why the surviving spouse would have a reaction to Brian Freedman's statements, given there was, this contention at some point. So I don't want to bag on the guy, on the surviving spouse. I don't want to bag on him at all. I think it's got to feel bad, but at the same time, I don't really think there was any legal wrongdoing here. And I guess we'll continue to get into this to explain why, right? So I want to be kind of cognizant of that. Is like, it's not going to feel good to be the guy's surviving spouse and to see his former attorney representing the former opponent. You know what I mean? Like that kind of sucks. But at the same time, it's like, I don't really think legal process was appropriate here. So I guess we'll see how it goes. 1 sec. Somebody says, I want a tiny violin. I have small hands. Hang on. So do I. Ready? I don't want to play it right now because I don't want people to think I'm playing it for the spouse here because, people take things out of context all the time when they clip stuff. That's not what I'm saying. So I'm not playing my tiny violin. I'm just trying to recognize, like, it must feel bad to be that guy's surviving spouse. All right, 1 sec. All right. Lauren has a tiny violin. Yes, I do. All right. Anyways. Flores' surviving spouse, Clement Sowery, filed this action in October 2025, alleging breach of contract, breach of fiduciary duty, legal malpractice, defamation, and invasion of privacy. This anti-SLAPP motion targets the claims and portions of claims arising from defendants' alleged statements and related conduct in connection with the highly publicized litigation between Lively and Baldoni over 2 years after Flores' case concluded. California's anti-SLAPP statute applies to the entire complaint before this court, and plaintiff cannot establish his burden to show that his claims have merit for multiple reasons. Okay. For example, estates may not bring defamation or privacy claims on behalf of the deceased. Freedman's statements to the press are protected by the fair report privilege, the litigation privilege, and because they contain no defamatory statements. And the entire complaint depends on the incorrect premise the defendants represented Flores and Baldoni at the same time, which they did not. The complaint in each of its causes of action should be stricken without leave to amend. Okay. So not just dismissed, but like blown off the face of the earth, basically, is what they're saying. All right. I hate how the stream just stopped. I don't know what you're talking about, man. It's been going for 18 minutes or so. All right. Ricardo Holt, thank you for the $5 Pacer funds. And just to say thank you, Lauren, for helping build this community. Y'all lovely. Have zero idea how many times being here has helped me. Oh, thank you so much, man. Happy to have you. Appreciate it. All right, let's go, dude. These are the statements of pertinent facts. Let's see. Flores copyright lawsuit against Baldoni and others. On July 8th, 2021, Flores signed an agreement with Freedman, engaging his law firm to represent him in connection with a dispute related to Ambry Genetics, Caleb Remington, an Ambry employee, Wayfarer, Justin Baldoni, CBS Films, and Lionsgate, arriving from theft of Flores' screenplay 3 feet distance and the development of the theatrical motion picture 5 feet apart. Okay, we know that already. This here, there's not too much that we really need to read that we're not going to find out later on, so I'm not going to go through everything word for word. CBS Films announced in January 2017 it had begun development of an untitled film from defendant Justin Baldoni and his production company Wayfair Entertainment about teens with cystic fibrosis. Baldoni's project, which had similarities to Flores' screenplay, became the film 5 Feet Apart, and Flores learned that Baldoni had consulted extensively about the content of 5 Feet Apart with Caleb Remington, one of the representatives of Ambry to whom Flores sent the screenplay for 3 Feet Distance. After the filing of the Flores litigation, defendants in the Flores litigation produced documents in support of their position that Baldoni had independently created 5 Feet Apart. Notably, counsel for Ambry and counsel for Baldoni produced extensive documentation that was unavailable to Flores and Freedman before the Flores litigation was filed, showing that Flores' allegations of access and copying were incorrect. So basically, after Flores filed this lawsuit, Baldoni's side produced all this documentation that showed Flores and Freedman that they had not copied Flores' work. All this stuff was happening before they even met Caleb Remington. So that's the cliff notes there. And they mentioned that 5 Feet Apart was actually based on inspiration from Claire Wineland, another sufferer of cystic fibrosis. And Baldoni did not meet Remington until after the allegedly similar events were already embodied in Baldoni's draft screenplay. Right. Okay. So since we're going to see so much about this later on, we're going to skim over here. Baldoni's entirely separate litigation with Lively over 2 years later. So Freedman first spoke with Baldoni over 2 years after the Flores litigation was dismissed, and he was engaged by Baldoni in late December 2024. On December 31st, 2024, 2 years and 9 months after the Flores litigation was dismissed, actress Blake Lively sued Baldoni, Wayfair, and others in federal court in New York. Okay. 1 second. In late January 2025, just a few days after Baldoni filed his countersuit against Lively, multiple press outlets began reporting on the fact that Freedman had previously sued Baldoni on behalf of Flores in the Flores litigation. For example, Us Weekly reported on January 23rd that before representing Justin Baldoni in his ongoing legal battle with Lively, attorney Brian Freedman found himself involved in a separate case involving the actor. The Us Weekly article described and quoted pleadings from the Flores litigation, noting that Flores had sued Baldoni for alleged copyright infringement and breach of contract. The article was later updated to include a comment from Freedman, clarifying a previous lawsuit he'd filed against Baldoni. And here's the quote. It says, "I learned that they did absolutely nothing wrong and there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfair or any other defendant's part." Freedman continued, "This only further confirmed to me that Justin and Wayfair are exceedingly honorable and highly ethical." Okay. So this is the kind of statement that Flores' surviving spouse, Clement, is upset about, and that's why they're suing him. Okay. I bet you though, that when Us Weekly published this article, they didn't mention the non-confidential walkaway settlement. So Freedman's statements to the media did not mention Flores and was not based on any information that Freedman had learned from Flores at any time. Okay. The Lively Baldoni litigation is not at all similar to the Flores litigation. And they go on to this action. On October 8th, Clement Sowry, Flores' surviving spouse and administrator of Flores' estate, filed this action against Freedman and LFTC, that's Liner, Freedman, Tatelman, Cooley, I think, on behalf of himself and Flores' estate, alleging, and then we've already read over those. So, plaintiff contends that Freedman's statements to the media defending Baldoni and Wayfair in the context of the Lively Baldoni litigation breached defendants' professional obligations to Flores and amounted to an invasion of privacy and defamation. All of the causes of action arise from speech and conduct in connection with judicial proceedings. So they're saying he can't be punished for his speech that's related to a judicial proceeding, right? So the law covers any written or oral statement or writing made in connection with an issue under consideration or review by a judicial body. Courts take an expansive view of what constitutes litigation-related activities. Under the plain language of the law, as well as the case law interpreting those provisions, all communicative acts performed by attorneys as part of their representation of a client in a judicial proceeding are per se protected as petitioning activity by the anti-SLAPP statute. Broadly applying the anti-SLAPP statute, as the court must, the anti-SLAPP statute also covers alleged conduct centered in defendant's role as counsel. Thus, even where alleged acts taken in the context of litigation are not communicative per se, they can still constitute conduct in furtherance of the exercise of the constitutional right of petition. All of the allegations giving rise to the 5 causes of action stem from statements and conduct in connection with the Flores litigation and or the Lively Baldoni litigation. This includes Freedman's statements to the media in the context of the Lively Baldoni litigation, which fall under Section 425, and I'm not going to read all that, even though made to persons who are not parties or potential parties of litigation. Okay. One sec, guys. Saw something about the 121 content creators coming for a class action lawsuit against Blake. As far as I know, there were only 107 of us, maybe 109 tops, 110. And no, I don't know anything about that. So if there is something about that and I don't know about that, I would like to be included in the email chain just so I know what's going on. I don't know if I want Blake Lively in my life long enough to do anything about that. But still, you know, it's nice to be included on the chain. You know what I mean? So... But no, I don't know of anything like that. I don't think there's much recourse, unfortunately, because this all happened in the context of a court case. And there's not, honestly, just not a lot of recourse for people who are non-parties to a lawsuit. No. But yeah, I would like to be invited to the email chain. I don't know if you guys saw, I did a spot on Prof. Joe Explains last night talking about the Lively Baldoni case. And I was just emailing her talking about this other case I was interested in. And she was like, well, I'm also really interested in just other high profile murder cases. I said, okay, if I see a murder happen, I'll think of you. Anyways. All right, let's move on. All of the causes of action also arise from speech on issues of public interest. So under the law, defendants must show their speech and conduct underpinning a cause of action occurred in connection with an issue of public interest. Like the SLAPP statute itself, the question whether something is an issue of public interest must be construed broadly. The public interest component has a 2-part analysis. First, we ask what public issue or issue of public interest the speech implicates, right? We look at the content of the speech. Second, we ask what functional relationship exists between the speech and the public conversation. All of the causes of action allege harm from Freedman's public statements to the media, which concern persons and matters of public interest. It's not hard to see why this was related to persons and matters of public interest. It's involving celebrities. Even if you don't think Blake Lively and Justin Baldoni are huge celebrities, Ryan Reynolds definitely is. So all of that was definitely high public interest. To pretty much the highest degree as far as celebrity news and stuff. All right. Here, according to plaintiff's complaint, there are several people in the public eye, including Flores, Baldoni, Lively, and Freedman. This is reinforced by media attention paid to each of these persons. The disputes and litigation underlying this matter are also matters of public interest. The Flores litigation, which involved a popular wide-release film, was a matter of public interest since the time it was filed in 2021. Also, the multiple media reports that plaintiff relies on in connection with Lively Baldoni readily confirm the intense public interest in that litigation, as Lively and Baldoni are both prominent celebrities embroiled in a heated legal dispute, which, as plaintiff puts it, excited a media storm and frenzy concerning a very high-profile public sexual harassment and defamation action. Freedman's statements to the media furthered the discourse about his representation of Baldoni in the Lively Baldoni litigation, while defending Baldoni's character, reputation, and credibility, and also accurately explaining that Baldoni had admitted no liability in the Flores litigation. Okay. Christina says, I'm curious what she would think of Laura Owens. That's what I was asking her about, actually. So, all right. Anyways, Plaintiff cannot satisfy his anti-SLAPP burden. Because defendants satisfy the first step of the anti-SLAPP analysis, the burden shifts to plaintiff to show a probability of prevailing on his claims. Under this second step, he must establish the causes of action are both legally sufficient and factually substantiated. Okay. Privacy and defamation claims cannot be asserted by a decedent's estate. So, you know, Travis Flores has unfortunately passed away as of, I think it's been almost 2 years now. And so they're saying that you can't do this on behalf of somebody who's deceased, right? Plaintiff alleges that Freedman made multiple public statements to national media outlets about Flores after his death and cast doubt on his integrity, credibility, and character, thereby defaming Flores. And like this, the statements that are being described here, I don't think they really cast any doubt on his integrity, credibility, and character. It's just the way that this stuff is portrayed by like social media and stuff. It makes it sound like there was this huge fight between Justin and Travis that ended with Justin like taking advantage of Travis's life story and all this crap. And that's not really what happened. It was a non-contentious, you know, non-confidential settlement where they all walked away because Travis, when he filed the lawsuit, did not know that Justin had started working on his movie, the script for his movie, long before they ever had any sort of connection or like mutual connection between them, right? And so like a lot of these statements about how in the lawsuit against Freedman here about how he cast doubt on Travis's integrity, credibility, and whatever, that's not true. And if it is true, it's because people on social media are misinformed and running rampant with inflammatory statements that don't actually make sense if you look at the actual legal documents and what happened in that case. So they're just trying to use that to defame or, you know, make inflammatory statements against Baldoni, saying that he did something wrong by making this movie about the CF community. And so when they say that Brian Freedman coming out saying Baldoni didn't do anything wrong is inflammatory towards Travis, they make it sound like they're saying Travis is a liar. That's not true. That's not what happened. What happened was they found out after the lawsuit was filed that there was no wrongdoing and everybody walked away. That's all that happened. A lawsuit was filed. They cleared the air, said, no, this is not what happened. I started working on the script long before I ever met our mutual friend, Caleb. They proved that to them, and everybody walked away. There was no legal matter to really dispute. And so people on social media might say there was this huge fight between Travis and Justin, but like ultimately it ended with no wrongdoing on anyone's part. And so is it defamation of Travis to say that Justin did nothing wrong? No, not really. I don't see how, but yeah, I don't know. I'm just saying like grief and loss do a lot to people. So I'm not trying to bag on the surviving spouse here. I'm just never going to be the person who's going to try to bag on the surviving. You know what I mean? Like, and I understand other people will see it differently and other people can be more objective, I think. But me in this situation, I'm just like, I really think no one was at fault here. And I think this lawsuit, I don't want to be like, F you, dude who filed the lawsuit. But at the same time, I want to be like, you got to get your shit together. I think what you're doing here is not productive. I think it's not going to be fruitful. You got to get your shit together. But I don't want to be like, F you, you're a terrible person for filing this, if that makes sense. Hopefully people understand me. But I don't know. This is kind of always how I approach things, I feel like. And that's frustrating for some people, but that's just how I am. So, all right. 1 sec. Okay. So this claim fails as a matter of long-standing, unambiguous, and well-established law. Defamation of a deceased person does not give rise to a civil right of action at a common law in favor of the surviving spouse, family, or relatives. Plaintiff similarly alleges that Freedman posthumously violated Flores' right of privacy by disclosing private and confidential information to the media and by disparaging commentary after Mr. Flores' death. The invasion of privacy claim likewise fails as a matter of law because the right of privacy dies with the person and cannot be asserted by anyone other than the person whose privacy has been invaded, such as an heir. The defamation cause of action fails for additional reasons. First, plaintiff alleges that Freedman's allegedly defamatory statements to the media harmed both Flores and Suri, but Freedman's statements were not about or of and concerning either Flores or Suri, which is a requisite element of a defamation claim. Such statements were about Justin Baldoni and Wayfarer. No part of them referenced Flores or Suri as individuals at all. Second, the court can and should determine as a matter of law that Freedman's statements did not imply anything defamatory about Flores or Suri. The only reasonable understanding is that Freedman was saying that Baldoni is good and honest, not that Flores or Suri, neither of whom Freedman mentioned, are or were bad or dishonest. And this is what I'm saying, like, that's not defamatory. Saying that Justin Baldoni is a good, honest person is not saying Travis Flores was a freaking psycho. You know what I mean? Like, that's not what's happening there. It's just crazy. So that's where I'm kind of like, yeah, I can understand why it sucks, because it could be very triggering, I think, to hear from Travis's, if you're still experiencing loss and grief, to hear from Travis's former attorney these nice things about his former legal adversary. I feel like it could be potentially emotionally triggering, you know, bringing up some stuff. But that's really a thing to deal with a grief counselor or a therapist before you kind of like go out and be like, well, you're defaming because you said he was a good guy. But like, you guys also acknowledged that there was no wrongdoing and walked away. So how is it then defamatory to say he's an honest person? Because you basically admitted that when you did the walkaway settlement, the non-confidential walkaway settlement. There was like no wrongdoing on anyone's part. It's kind of like, that's tough. That's tough. Like, legally, I don't think the widow or the surviving spouse is going to get much. I really don't. But I don't know. I tend to think that loss and grief complicates things. And sometimes it gets the better of your common sense or your logic. Sometimes it gets the better of your, let's think about this before I take the next step and try to trigger a lawsuit. Like, I know I see a lot of people saying cash grab, but I'm like, maybe it's a little bit of both, right? Maybe it's a little bit of both. Maybe there was a little bit of grief that went into that was just kind of like, I want revenge. I'm seeing red, and that's how that happened. I don't know. I tend to give people the benefit of the doubt, though, even if they do stuff I don't like. Even if they do stuff that I don't like that's against me. So, that's just how I've always been. So, all right. Anyways. Third, Freedman's comment about the Flores litigation ending without any liability is protected as substantially true because it accurately recounted the non-confidential Flores settlement agreement terms. Got it. Fourth, Freedman's views that Justin and Wayfarer are honorable and ethical, are not liable, are statements of protected opinion. The First Amendment bars defamation claims based on statements that cannot reasonably be interpreted as stating actual facts about an individual. Right. The invasion of privacy cause of action also fails for additional reasons. To the extent plaintiff's privacy claim is for the alleged publication of private facts, it fails for the additional reason that the allegedly actionable statements did not reveal anything private or confidential. The Flores settlement was not confidential, and Freedman did not reveal any information that he received in confidence. The claim further fails because summarizing the non-confidential settlement would not, as a matter of law, be offensive and objectionable to the reasonable person. Right. That doesn't even make sense. That doesn't make sense. He's being asked as an attorney to give a statement on a case that he worked on, a very public, high-profile case that he worked on. Summarizing the non-confidential settlement is not an offense. Like, that doesn't make any sense, right? One sec. Danny kind of put this better than I could, which is, I think family members many times seek closure that doesn't exist with civil lawsuits, including many wrongful death cases. I think so, yeah. I mean, when you're still feeling emotional and offended and like upset and depressed even or grieving, it's like sometimes you take action because there's no other action to take. Like there's nothing you could do to kind of fill that feeling, to fix that feeling. It's like you feel like somebody has wronged you in some way. It's like you're not necessarily correct in that, but the feeling is real. You know what I mean? Like you're telling the truth about how you feel and what you think and how you feel like somebody wronged you, but it's not necessarily objectively correct. So that's kind of what I was getting at. Yeah. All right. To the extent the privacy claim is for a false light, and is here based on the same allegations as a concurrent defamation claim, it's superfluous and must be dismissed. To the extent privacy is meant to be invoked by Suri individually, there's no allegation or basis for such a claim because none of the privacy invading speech or conduct is about Suri. So none of the allegations of this speech, even if correct, was even about Suri. So as an individual, I'm not really sure what recourse Suri thinks that they have, right? And I see like a comment, Ryan is paying them to do this. And that's exactly why I kind of get into the weeds on the motivations for stuff like this. Because like, I understand Ryan Reynolds is like more chronically online, I'm pretty sure, than most of us from what I've seen in discovering this lawsuit. But I don't want to write things off or write people off and their feelings off as Ryan Reynolds paid for this or inspired this any more than like I think it's right for anyone to say like Justin Baldoni's team paid me to not like Blake and Ryan. You know what I mean? So like I'm very careful with this stuff. And if I don't see anything objectively pointing me to Ryan Reynolds funded this and told him to do this, I'm the type of person who's going to be careful and I'm not going to say stuff like that. But I understand where it's coming from. You know, I totally do. All right. We all need tinfoil hats. I would wear a matching tinfoil hat. Let's do it. But I'm not going to do it alone. So I'm less chronically online than Ryan Reynolds. Ryan Reynolds really is. And when you look at his text to Colleen Hoover, or emails especially to Colleen Hoover, Ryan Reynolds is chronically online. Oh my God. Imagine if you were like so rich and powerful and you were that chronically online. Like, brother, we don't have the money to go do something else. You do. Go away. Like, leave us alone. Seriously. Anyways. All right. The claims are circumscribed by the absolute fair report privilege. Civil Code Section 47D provides a publication is privileged if it's a fair and true report in or a communication to a public journal of judicial or other public official proceeding or anything said in the course thereof, which the fair report privilege is kind of like what protected the New York Times. Although the fair report privilege is typically invoked by news media defendants like the New York Times, it also protects those who communicate information to the media. Right. Okay. Each cause of action is based in whole or in part on Freedman's statements to the media in the context of defending Baldoni in the lively Baldoni litigation. Freedman fairly and accurately described the Flores settlement. The case was resolved without any liability on Justin's or Wayfair or any other defendant's part. Okay. And all parties to the Flores litigation settled without any admission of liability. Right, exactly. Each of the causes of action is therefore barred, at least in part, by the absolute fair report privilege. I cannot talk. The litigation privilege bars liability for Freedman's statements to media. So all of his statements to the press were made in connection with the Baldoni Lively case. They're protected by Civil Code Section 47B because of the absolute litigation privilege, as it should be, in my opinion. But the privilege applies to statements made in the course of a judicial proceeding by litigants or other authorized participants and that aim to achieve the litigation's objects and have some logical connection or relation to the litigation. So he's pretty much good on all counts there. The privilege extends beyond court filings to conduct outside the courtroom and post-trial, even if no function of the court or its officers is involved. The privilege bars plaintiffs' claims as to Freedman's litigation-related communications, Freedman's statements to the public and media in defense of Baldoni, which serve in part or in toto, which is a term I'm not used to. All I can think of is that little dog from, God, what's it called? Oh my God, what is the movie with the yellow brick road and the Munchkins? Oh my God, guys, I forgot the name of the movie with Toto the dog. We're not in Kansas anymore. How can I not remember the name of this? I know this. Dorothy, we're not in Kansas. Oh my God. Something's wrong with me. Someone help. Anyways, which serve in part or in toto to underpin each of plaintiff's causes of action, which just means in total, in whole. Relate to the lively Baldoni litigation and summarize the results of the Flores litigation. Okay, my brain is breaking right now. Wizard of Oz. Yes, I know the Wizard of Oz. Like, I'm not stupid. I know the Wizard of Oz. I don't know why I forgot that. Anyways, they did not. First, the complaint incorrectly assumes defendants represented Flores and Baldoni at the same time. They did not, because Freedman never represented Flores and Baldoni at the same time. There was never a conflict of interest. Second, Freedman's subsequent representation of Baldoni was not in the same matter, nor is the lively Baldoni litigation substantially related to the matter in which he represented Flores. Okay. The two cases have nothing in common except Baldoni and his company Wayfair are parties in each. Thus, Freedman's current representation of Baldoni does not present a conflict under Rule of Professional Conduct 1.9. Third, Freedman did not reveal any of Flores' confidential and/or attorney-client privileged information. His statement to the media that the Flores litigation was resolved without any liability by Justin or Wayfair or any other defendant is true, first of all, but also merely restated the no admission of liability provision of the non-confidential settlement. That statement and Freedman's opinions of Baldoni's character were also based on information that Freedman learned from his review of materials produced by the defendants, not Flores, in the Flores litigation, including information about Baldoni's charity work. Freedman did not disclose anything to the public or media that he learned from Flores, and therefore did not violate the professional conduct. Fourth, as with the privacy claim, because the contract, malpractice, and fiduciary duty claims are based in part on Freedman's alleged public statements about Flores' reputation and character, they are superfluous and fall within the defamation claim. All right. And then I wanted to read a little bit from Brian's declaration here. Give me one sec. Not the whole thing, but... Let's read that one. Juicy Prusy, I'm going to say. Thank you for the $10. What are your thoughts on all these lawsuits being filed now against Melissa Nathan and Brian Freedman? It's giving Ryan Reynolds thoughts. Lauren, you're awesome and so smart. Thanks for all you do. Thank you very much. As far as the lawsuits, I think they're all about like smear campaigns and stuff. The Amanda Ghost lawsuit, Rebel Wilson, Amanda Ghost, I know mentioned them. And I know there's the Alexa Nicholas. Is that her name? Lawsuit. I haven't been able to read through them all yet. Somebody sent them to me, so I have the documents, but I haven't been able to read through them all yet. My opinion is whatever is going on with these like crisis PR people and the lawsuits where it's like Brian Freedman is also the attorney and the crisis PR people are, you know, working with the defendants or whoever. Like Brian Freedman as an attorney is allowed to work with certain PR people and like get recommendations from certain PR people to represent their clients. You know what I mean? So like the connection there is like kind of a no-brainer. It's like, of course you're taking clients referred to you by somebody you already know and have worked with in the past. Like that's just business. That's not really weird. As far as Melissa Nathan goes and the crisis PR goes, I feel like the situation with Blake Lively is very different potentially than the situation with like Amanda Ghost, Rebel Wilson, or this Alexa Nicholas thing. And as far as I can tell from the Alexa Nicholas thing, it's hinging on the claims in the Blake Lively lawsuit and the claims in the Wilson Ghost lawsuit being correct. So in what I saw when I skimmed over it, because I haven't read it yet, so I'm not going to, say anything for certain yet. My opinion is, from what I have seen so far, her claims hinge on those claims being true. And so since there's not been a judgment there and there's no judgment that is actually happening, it's hard to take too much credibility there, but it's not like nothing isn't fishy. I'm going to be honest with you. Like, I think the crisis PR teams, like, they do some crazy shit that I didn't even know was possible as far as media manipulation. I just don't think it has anything to do with Justin. Because we've seen that Justin and Jamie and Wayfair at least told them not to do anything negative. So if these people, these crisis PR people are actually doing all these crazy things behind the scenes, it's like they were told not to by their clients. And therefore I think that's not the fault of Justin. That's not the fault of Jamie. That's not the fault of Wayfair. So it's going to be, it's going to come down to a couple things. Number one, is it even true in the Baldoni case, since they're citing the Baldoni case as proof? And second, did that actually happen without the client's consent? Because that then has a lot to do with like the responsibility. Was it like, did the client actually order this? Did the client ask for this? Or is the crisis PR team just doing this to build their business and be like, look, we can bury anyone, hire us. So I don't know. There's so much I can't say until I read through this stuff. I have not gotten all the Rebel Wilson Amanda Ghost documents, so I can't say too much on that. Like I said, skimmed over the Alexa Nicholas thing, and it seems like it hinges mostly on claims that have not yet been proven in a court of law. So I can't really put too much stock into that yet. But it's something that I'm considering. I'm not going to say just because Melissa Nathan worked for Justin Baldoni at some point in time, I can never criticize her. You know what I mean? It seems like she does do some stuff that wasn't necessarily approved based on Justin's deposition. So my thoughts are, it's possible that she's sketchy. It's possible that she's a sketchy character and that her agency does stuff they're not supposed to and that are not necessarily above board. But I'm not going to crucify them without having a firm grasp of that, if that makes sense. So, yeah. All right. Anyways. Somebody says, from the beginning, I've thought Jed and the Crisis PR people seem shady. I mean, it's possible. It is totally possible that they are shady and that they do sketchy, nasty shit. It's totally possible, and it's totally possible that that is not the fault of anybody but them, because nobody asked them to do that. You know what I mean? So, I'm not going to give a full opinion yet. Let's put it that way. But I will say that they kind of freak me out, man. The PR people, they kind of creep me out. They're all look at these people. They're all shadow people. They don't have a legit public profile, and it's just it's weird. There's a little weirdness there to me, but I can't really say that they're guilty of anything. You know what I mean? I can't. So I won't, at least not right now. Okay. Thank you for the question. Sorry for the rant. All right, anyways, here's the declaration of Brian Freedman in relation to what we've been reading. It says, after the Flores litigation was filed, the defendants in the Flores litigation, so the defendants being Justin and co., explained they did not have access to Mr. Flores' script and that the 5 feet apart was independently created. Right. Mr. Grossman, who was the attorney for Justin and Wayfair, says, Mr. Grossman's letter explained his client's lack of access to Mr. Flores' script for 3 feet distance and their independent creation of 5 feet apart in detail, and also highlighted Mr. Baldoni's charity work. Okay. Because his charity work is how he got connected with a lot of people in the CF community. So, in addition, after the filing of the Flores litigation, the defendants in the Flores litigation, defendants being Baldoni and company, trying not to burp, produced documents in support of their independent creation and lack of access positions. In particular, defendant Ambry produced nearly 1,500 documents, none of which contained any indication that Ambry had shared Mr. Flores' script with any third party, including Mr. Baldoni. Such materials were not available to me or Mr. Flores before the Flores litigation was filed. After multiple stipulations to extend the response deadline and after providing time to review the evidence presented, Ambry moved to dismiss Mr. Flores' complaint for failure to state a claim. On March 9th, 2022, the parties to the Flores litigation entered into a non-confidential settlement agreement, the Flores settlement, that settled all of the claims in the litigation. In January 2025, media publications covering the Lively Baldoni litigation reached out for my comment on the publicly available fact that I previously represented Mr. Flores against Mr. Baldoni in an entirely separate matter in 2021, the Flores litigation. I responded with a statement that did not mention Mr. Flores, and I did not base any part of my statement on any information, confidential or otherwise, that I obtained from Mr. Flores. My statement summarized the non-confidential terms of the Flores settlement and information obtained from the defendants, not from Mr. Flores, in the course of the Flores litigation. My statement was also based on information I learned about Mr. Baldoni's heavy involvement in charity work, including the fact that his production company, Wayfair Entertainment, had set up a foundation for charity purposes. A true and correct copy of an example of my statement in response to media inquiries on this issue is attached to this declaration. I have never revealed any attorney-client or confidential information obtained from Mr. Flores to the public or to the media. Yeah. All right. Okay. This declaration was from the attorney. I don't really need to do that. There's a little bit from this letter here that I'll read to you guys, but I'm not going to read the whole thing, obviously. This is from, let's see, it's to Brian Freedman, I believe, from Grossman, the attorney for Justin in that Flores lawsuit. Okay. So this is Justin's attorney speaking. It says, "My clients take such allegations very seriously." Give me 1 second, guys. All right. "My clients take such allegations very seriously. Accordingly, we have investigated the claims in your letter and complaint, and we can assure you and Mr. Flores that his work was not copied in any way. Rather, our investigation has confirmed that, as Mr. Flores knows, the film was inspired by Claire Wineland, a cystic fibrosis patient who was featured in Wayfair's web series My Last Days. Neither Mr. Baldoni nor the film screenwriters ever knew of, much less accessed, the Flores screenplay, and therefore could not have used it in order to create the film. Your letter and complaint speculate that Mr. Baldoni obtained access to the screenplay through an individual named Caleb Remington. However, documentary evidence establishes that Mr. Baldoni and Mr. Remington did not even meet until after the first draft of the film's screenplay, which contained virtually all of the elements of the film that Mr. Flores pleads are similar to the elements in his screenplay, had already been written. This evidence conclusively establishes that the film was independently created and its authors could not have seen, let alone copied, any elements, protectable or otherwise, from the Flores screenplay. Further, a review of the works in question reveals that there is no legally cognizable substantial similarity between them. Any minor similarities between the works stem from the fact that both center on teenage characters suffering from serious diseases like cystic fibrosis in the film and various other maladies and terminal diseases, including CF, in the Flores screenplay. And both contain certain stock elements that flow naturally from this unprotectable subject matter and from the teenage romance genre in general. This does not support a copyright infringement claim as a matter of well-settled law. In the complaint, Mr. Flores speculates that Mr. Baldoni received a copy of the Flores screenplay from Mr. Remington. This is not just untrue, it is chronologically impossible. Mr. Baldoni did not even meet Mr. Remington until late April 2017, after the above allegedly similar elements were already embodied in the film's first draft screenplay. When Mr. Remington, who is also a member of the CF community, became engaged to Tiffany Au in 2017, they decided to create the greatest wedding ever donated, using their special day to raise funds for charities focused on issues important to them, including rare diseases and low-income families. Fans of Mr. Baldoni's work on My Last Days, and aware of Wayfair's charitable endeavors, Mr. Remington and Ms. Au emailed Wayfair in April 2017 to inform them of the GWED and to see whether Wayfair would like to be involved. Attached as Exhibit A is an email chain, right, in which Mr. Baldoni is first introduced to Mr. Remington. The email chain conclusively demonstrates that Mr. Baldoni did not even know Mr. Remington until after the first draft screenplay for the film was written. Thus, Mr. Flores' speculative theory of access is demonstrably incorrect. Even if the Flores screenplay was similar to the film, and it is not, his claim would fail because there was no coherent theory of access to his unpublished work. Instead, there was demonstrable evidence that the film was independently created, and Mr. Flores cannot satisfy the requirement of proving actual copying. Your October 1st letter also confusingly suggests that Mr. Remington, who is not a writer, somehow himself infringed the Flores screenplay, and that my clients are vicariously liable for his purported infringement. While I do not represent Mr. Remington, this allegation is nonsensical. Mr. Remington played no role in writing the film. Moreover, all of the relevant aspects of the film were already written before Mr. Remington ever met Mr. Baldoni. All right. So I just thought that gave some insight into the issues of like what was going on with the alleged copyright infringement and why it was let go the way it was. With no liability, everybody walked away. So, yeah. All right. Look at this hair, man. Gotta do something about that. So like I said, guys, I'll be on Omar's channel at midnight Eastern. It's currently 10:50 Eastern, so that's a little over an hour. When I end this stream, it will redirect you in the chat to a link to Omar's channel where I'll be talking. Like I said, it's going to be very political and it'll be very different subject-wise. So we'll, get some different stuff over there. If you want to watch, totally do that. If not, that's not your thing, then you don't have to. But all right, appreciate it, everybody. Thanks, and I will be back soon. Bye.